Welcome to the deep dive. If you are listening to this right now, we know exactly who you are.
Yeah, we definitely do.
You are a professional planner, and you are, well, deep in the trenches of studying for a really rigorous professional exam,
Right.
and you are likely juggling a very demanding day job on top of this absolute mountain of required reading. So today, we are taking one of those really critical, dense pieces of reading completely off your plate.
Absolutely. It's a heavy one, but we've got you covered.
We are going to unpack the academic article Human Rights and the City, A View from Canada by Sandeep Agrawal. This was published in the Journal of the American Planning Association.
Right.
And the author's main thesis here is that day-to-day municipal planning matters are increasingly and sometimes really forcefully colliding with fundamental human rights in Canada.
Yeah, it's a major friction point right now.
He argues that the Canadian state and the judiciary are actively stepping in to safeguard human rights at the city level. And that completely changes how planners have to approach everything from, drafting zoning bylaws to managing public spaces.
It really is a massive shift in the profession. And what makes this specific article so vital for your exam, and honestly for your future career, is how it bridges the gap between high-level constitutional philosophy and the literal concrete of the city.
Right, because theory is one thing.
Exactly. I mean, we all agree on human rights in principle.
Right.
But this text looks at what happens when those rights dictate exactly where you can build a group home, or whether a city can clear a homeless encampment out of a public park.
Which are huge everyday issues for a planner.
They are, and the author lays out a detailed framework of legal cases and specific constitutional sections that dictate what a planner can and cannot do. By the end of this deep dive, you are going to understand the exact mechanisms of these legal clashes.
You'll have the specific rulings you need to know, right?
Yes, the rulings and the underlying logic the courts use to actually decide them. This is highly testable material.
Okay, let's unpack this. The text begins by grounding us in what it actually means when we say human rights. It defines them as moral rights of the highest order.
Rooted in the UN's 1948 Universal Declaration of Human Rights.
Right, the United Nations. They are the inalienable rights we all possess just by virtue of our inherent dignity. But as a planner, you aren't usually referencing the UN when you draft a setback requirement.
No, definitely not.
So how does the article explain the way these global concepts actually translate into Canadian law?
Well, the author makes a very clear distinction that you need to have locked down for the exam. In Canada, human rights are codified in two distinct forms.
Okay, what are they?
Constitutional and quasi-constitutional. Let's look at the constitutional form first. This is the Charter of Rights and Freedoms, which is part of the Constitution Act of 1982.
Right, the Charter.
But the defining feature of the Charter, and the thing that trips up a lot of people on the exam, is that it applies exclusively in relation to government activities. It's a shield that protects the individual from the power of the state.
So if a private citizen discriminates against another private citizen, the Charter doesn't actually apply.
Exactly. It does not apply to private interactions. And that is where the second form comes in, which are the quasi-constitutional laws. These are the federal, provincial, and territorial human rights acts. So think of the Canadian Human Rights Act at the federal level, or something like the Ontario Human Rights Code at the provincial level.
And those operate differently.
They are broader in their daily application because they encompass both private and public acts. They govern the provision of goods, services, facilities, employment, accommodation. So if a private landlord discriminates against a tenant...
That is a violation of the Provincial Human Rights Code.
You got it.
So how do these quasi-constitutional laws interact with normal municipal bylaws,
Yeah.
like the ones our listener will be drafting?
They are incredibly powerful. The text points out that these quasi-constitutional laws supersede all other laws when conflicts arise.
Wow. All other laws.
Yes. Now, there are overlaps between the charter and these provincial codes, especially when a municipal government is the one providing a service or a facility. But understanding that two-tiered structure is the foundation of everything else the author discusses.
The text highlights a few very specific sections of the charter that seem to be the ones planners keep tripping over. Which ones should our listener absolutely have highlighted in their notes right now?
There are 4 key sections you need to know. First is Section 15. This guarantees equality before the law and the right to equal protection and benefit of the law without discrimination.
And it lists specific grounds, right?
It does. It specifically lists grounds like race, national or ethnic origin, color, religion, sex, age, or mental or physical disability.
Okay, Section 15 is equality. What's next?
Then there is Section 2, which guarantees fundamental freedoms. That includes freedom of religion, thought, belief, and expression. Third is Section 7, which guarantees the right to life, liberty, and the personal security of all Canadians.
Those sound fairly absolute. I mean, is there any wiggle room for a municipality if they have a genuinely compelling planning reason to restrict something?
That brings us to the fourth one you need to memorize, which is Section 1. Section 1 is the Balancing Act.
How so?
It states that all these rights are guaranteed, subject only to reasonable limits prescribed by law, as can be demonstrably justified in a free and democratic society.
So a right can be limited.
It can, but the government has the burden to prove that the limit is reasonable and justified.
Okay, so what happens when a city drafts a zoning bylaw that crosses the line and violates one of those sections? Let's say it violates Section 15's equality provision. What's the fallout?
If we connect this to the bigger picture, the text introduces a critical legal concept here called ultra vires.
Ultra vires?
Yes. It's a Latin term meaning beyond the powers. Municipalities only have the powers delegated to them by the province. They do not have the power to violate the Constitution.
Right, obviously.
So if a planner drafts a bylaw that is inconsistent with the charter, it is ultra vires. It is legally invalid. This isn't just a matter of poor urban design. It invites massive, costly litigation that can result in the bylaw being completely struck down by the courts.
And the article moves from these broad constitutional definitions straight into how they crash into local zoning. And it uses some fascinating real-world case studies to illustrate the friction. Here's where it gets really interesting. Let's look at the first major case from Toronto in 2010.
Right, the group home case.
Exactly. The setup is that a housing advocacy group composed of psychiatric treatment survivors challenged the City of Toronto's proposed citywide zoning bylaw. The city wanted to force group homes to be located at least 250 meters apart from one another. Yeah. Why would a city push for a mandatory separation distance like that?
Well, often municipalities implement these distances in response to neighborhood pushback. Residents express concerns about the character of their neighborhood changing, or they worry about a concentration of social services in one area. So the city tries to use zoning to physically disperse the group homes.
But the author of this article, Sandeep Agrawal, actually served as an expert witness in this specific legal challenge, didn't he?
He did. The case is called Dream Team v. the City of Toronto. He reviewed the city's definition of group homes and those separation distances, and he found severe legal flaws.
What was the core argument against the 250-meter rule?
The argument, which the Ontario Human Rights Tribunal ultimately supported, was that this rule violated Section 15 of the Charter, the equality provision.
Because it targeted a specific group.
Exactly. By creating a specific, restrictive spatial requirement for homes where people with mental health-related disabilities live, the city was discriminating based on disability. It also violated the Ontario Human Rights Code. And furthermore, it violated a specific piece of the Ontario Planning Act, Section 35(2), which explicitly prohibits what is known as people zoning.
Let's pause on that term. What exactly is people zoning? That sounds like a perfect exam question.
It is a fundamental principle in planning law. You have the authority to zone for land use. You can say this parcel is for residential use and this parcel is for commercial use. But you cannot zone based on the characteristics, identities, or relationships of the people using the land.
So you can zone the building, not the occupants.
Precisely. You can't say this house can only be occupied by people related by blood, or these residents must be a certain age. Or in this case, people with psychiatric disabilities must live 250 meters apart.
When the tribunal ruled against Toronto, what was the fallout? Did it just affect that one specific bylaw in Toronto?
The ripple effect was enormous, and this is a highly testable outcome. Toronto was forced to amend its definition of group homes, completely removing the minimum separation distance and deleting any phrasing that identified the characteristics of the residents.
But it went further than Toronto, right?
It did. The province of Ontario actually updated its provincial policy statement in 2014, mandating that every single municipality in the province ensure their plans and bylaws comply with the Charter and the Human Rights Code. The text notes that Ontario is currently the only province that has explicitly embedded this requirement into its overarching planning policy.
That is a massive precedent. It shows how one discriminatory bylaw can reshape the planning framework for an entire province. Let's look at the second case study the author provides. This took place in the village of LaFontaine, Quebec, spanning from 1992 all the way to 2004.
This one is about places of worship and freedom of expression.
Right. The scenario is that a congregation of Jehovah's Witnesses needed land to build a place of worship. The municipality's zoning bylaw only permitted places of worship in a specific regional community use zone. The problem was there was literally no suitable land available for sale in that zone.
It's a very common practical issue. When the zone land is unavailable, the applicant looks elsewhere. So the congregation purchased a parcel of land in a commercial zone instead, and they applied to the municipality for a rezoning change to allow their place of worship.
And the municipality outright refused the application.
They did, and crucially, they provided zero explanation for the refusal. They essentially invoked absolute municipal discretion and just said no.
Now, if a city council is elected to make these local land use decisions, don't they have the discretion to say no to a rezoning application?
They do have discretion, but discretion is not a blank check, especially when constitutional rights are engaged. This case went all the way to the Supreme Court of Canada, and the court sided with the congregation. They ruled that the municipality had acted in bad faith. The text uses the term procedural fairness.
What does procedural fairness actually mean in a planning context?
It means that the process by which a decision is made must be fair, transparent, and justifiable. When an application engages a fundamental right, in this case, freedom of religion under Section 2A of the Charter, the municipality cannot just arbitrarily deny it without a valid planning rationale.
So they can't just silently block them.
Right. By refusing to justify its decision, the municipality breached its duty of procedural fairness. The Supreme Court made it clear that a local government cannot use zoning as a quiet tool to exclude an unpopular religious group from their community.
These clashes over group homes and churches are complex enough, but the article dives into even more intensely political immediate crises. How does this legal framework play out when a city is dealing with something like homelessness and the use of public space? Because planners are often caught right in the middle between local residents demanding action and the reality of a housing crisis.
These are arguably the most difficult challenges in modern urban planning. And remember, we are just looking at the legal facts from the text here.
Right, just the legal precedents.
The text explores several landmark cases regarding homelessness, specifically Abbotsford v. Shantz and Victoria v. Adams. In these cities, municipal governments passed bylaws that prevented homeless individuals from camping or erecting temporary shelters in public spaces like city parks overnight.
What happens when those park bylaws are challenged in court? How do the judges untangle municipal park management from constitutional rights?
The courts ruled that these specific anti-camping bylaws breached Section 7 of the Charter.
The right to life, liberty, and personal security.
Yes. The judicial reasoning here is vital to understand. In the Abbotsford case, the judge found that interfering with a homeless person's fundamentally important personal decision to shelter themselves violates their liberty interest. But, and this is key, only under a very specific condition.
Which is?
When there is no practicable alternative shelter available.
So the city's ability to enforce the bylaw hinges entirely on whether they have provided enough actual shelter beds.
Precisely. If the municipality has not ensured that there are adequate, accessible, and safe alternatives for people to sleep, they cannot legally use their bylaws to ban people from surviving in public spaces. It fundamentally alters how cities can manage parks. You cannot enforce a prohibition on public camping if the people you are evicting have literally nowhere else to go.
The text also brings up safe injection sites, pointing to the PHS Community Services case regarding the Insight facility in Vancouver. Now, I can imagine the neighborhood pushback against zoning for a safe injection site is intense. Local business associations and residents often fight these permits aggressively.
They really do. And municipalities frequently try to block or delay these facilities through zoning and permit denials to appease those local concerns. But the Supreme Court stepped in here as well, again relying on Section 7 of the Charter.
How did they weigh it?
The court weighed the concerns of the community against the immediate health needs of the individuals dealing with addiction. And the ruling was clear. The health benefits of these sites, specifically that the risk of morbidity and mortality is significantly reduced when injection happens under medical supervision, those benefits far outweigh any detriment to the surrounding community.
So denying the permit is seen as a direct threat to the users' lives.
Yes. The court stated that denying access to these critical health services violates the client's Section 7 rights. Furthermore, the courts dismissed the opposition from business associations, noting that the sites did not unfairly burden the community or violate the procedural fairness of the neighbors.
So what does this all mean for the planner listening?
The overarching theme across all these cases is that when municipal planning decisions push back against fundamental human rights, the courts almost universally support the federal constitutional law over the local municipal bylaws.
It sounds like the courts are constantly having to step in to correct municipal overreach. But the author doesn't just focus on the failures. The article highlights positive steps cities are actually taking to align their planning with human rights. What are some examples of progress that a planner can look to for guidance?
The author provides 2 detailed tables in the text outlining this progress. To give you a few concrete examples for your essays, British Columbia became the first jurisdiction in Canada to pass legislation formally implementing the United Nations Declaration on the Rights of Indigenous Peoples.
Which brings Indigenous rights directly into the land use conversation.
Exactly. Over in Alberta, Calgary took a major step by completely removing its prohibition on secondary suites in residential areas.
That sounds like a simple zoning tweak.
It might, but it directly impacts access to affordable housing by legalizing basement apartments and backyard suites across the entire city. And in Quebec, Montreal actually adopted its own municipal charter of rights and responsibilities. This municipal charter allows citizens to initiate public consultations and establishes an independent municipal ombudsman to investigate complaints.
Those are great proactive measures. But the text also dedicates space to outstanding areas of concern. What are the limits of human rights law in planning? What hasn't the charter been able to solve?
This is a crucial area for your exam because it defines the boundaries of the law. The author points to a very significant case called Tanuja v. Canada.
Tanuja v. Canada.
Got it. In this case, the applicants tried to push the boundaries of Section 15 and Section 7. They argued that the state of inadequate housing and homelessness in the country violated their rights. Specifically, they wanted the court to declare that inadequate housing is an analogous ground for discrimination under Section 15.
Wait, what exactly is an analogous ground in Canadian law? Does that just mean characteristics that aren't explicitly written in the charter but are treated the same way by the courts?
That is a perfect way to describe it. The text of Section 15 lists specific protected grounds, like race, religion, and age. But the courts have recognized over time that the list isn't exhaustive. They have added analogous grounds, things like sexual orientation or marital status, that are deeply personal, immutable, or constructively immutable characteristics.
So the applicants in the Tanuja case were arguing that housing status or poverty should be recognized as an analogous ground, meaning the government couldn't enact policies that disproportionately harm the unhoused.
Sure.
Did the Supreme Court accept that argument?
They did not. The Supreme Court rejected the idea that inadequate housing is an analogous ground. But even more significantly, they ruled that Section 7 of the Charter does not provide a positive right to affordable, adequate, or accessible housing.
What's fascinating here is the terminology. What is the difference between a positive right and a negative right in this context?
It is a massive philosophical distinction that dictates how the state operates. The current interpretation of human rights law in Canada is primarily focused on negative rights. This means the state must stop doing things that actively harm you.
Like, a city cannot actively ban a group home.
Right. A city cannot actively tear down your tent if there is no alternative shelter. The law protects you against active state discrimination.
But a positive right would mean the state has to actively provide something.
Exactly. The court ruled that the charter places no positive obligation on the state to proactively fix the root problem of homelessness. It does not force the provincial or federal government to spend billions of dollars to build thousands of affordable homes. It stops the city from punishing the homeless through bylaws, but it doesn't force anyone to actually house them.
That is a harsh reality for a planner to manage. You are told by the courts that you cannot use zoning to sweep poverty out of public spaces. But the courts also aren't forcing the higher levels of government to fund the housing needed to solve the crisis. Planners are basically left holding the bag, managing the day-to-day friction on the ground.
They really are.
Given these immense challenges, how does the author suggest the profession moves forward?
Agrawal's conclusion is a bit of a wake-up call for the profession. He notes that human rights legislation is not a magic remedy for all urban problems. Progress is incredibly slow. It is often blocked by entrenched institutional biases, intense local power politics, and frankly, a severe lack of awareness among planners themselves.
Planners just don't know the law.
Many simply lack the constitutional training to spot a human rights violation in a zoning draft before it turns into a lawsuit. To counter this, he offers 3 specific industry critiques and recommendations.
Okay, what is the first recommendation? Listener, get your pens ready.
The first is comprehensive training. Municipalities need to institute formal training programs for their municipal planners and local politicians. They need to understand the provisions in the national constitution and provincial human rights legislation, and understand exactly how those legal frameworks supersede local planning policies.
A city councilor shouldn't be learning about procedural fairness for the first time while being sued by a religious congregation.
Exactly. That's a costly way to learn.
That makes perfect sense. What is the second step?
The second is rigorous document review and public education. Municipal officials need to actively audit their existing zoning documents from a human rights perspective. Find the discriminatory language and remove it before a tribunal orders you to.
And what about the public education piece?
The author suggests developing a citizen's guide to zoning. This guide should clearly explain the actual planning rationale for restrictions. If there is a setback requirement, explain why it exists for fire safety or infrastructure needs.
I see. This educates the public on the difference between a valid planning rule and an arbitrary restriction used to keep certain people out of a neighborhood.
Precisely. It builds trust and transparency.
And the final recommendation looks to the future of the profession. Right?
Yes. The third recommendation targets curriculum updates. Planning schools need to revise their curricula. Students are taught how to calculate floor area ratios and draft official plans, which is great, but they also need dedicated course content covering human rights history, philosophy, theories, and law.
They need the whole context.
They need to learn how these legal structures intersect with the physical layout of a city before they enter the workforce. Though I think it's fair to say that by spending the time on this deep dive, our listener is already taking a huge step toward bridging that knowledge gap.
We certainly hope so. We want to genuinely commend you for taking the time to tackle such a dense, complex topic. We know you are busy, but understanding this intersection of law and urban design is what separates a good planner from a truly great one. We are confident that you are now armed with the legal precedents, the specific charter sections, and the real-world friction you need to excel on your professional exam.
Before you get back to your study guides, I want to leave you with a final thought to mull over, building on everything Agrawal discusses. We have seen that the courts will intervene when a zoning bylaw explicitly discriminates, like the Toronto group home case or the LaFontaine religious freedom case. But think about the layout of your own city right now.
Right.
How many seemingly neutral zoning laws, things like strict single-family zoning, the specific routing of public transit, or parking minimums, are quietly creating invisible walls that no human rights tribunal has challenged yet? As a future planner, will you wait for a lawsuit to tell you it's wrong, or will you be the one to dismantle the wall from the inside?
That is a very powerful question to carry with you into your career. Thank you so much for joining us on this deep dive. We wish you the absolute best of luck on your upcoming exam. You are going to do great. Keep studying, keep asking the hard questions, and keep exploring how human rights shape the cities we live in. We will see you next time.